Disinheriting a child is a serious and complex decision that involves legal and emotional considerations. It is possible to disinherit your children, but the process requires specific legal steps to ensure the disinheritance is valid and enforceable. Below, we outline the key factors, legal requirements, and potential challenges involved in disinheriting a child. Key considerations. 1. Legal competency. Mental capacity. Ensure you have the mental capacity to make a will or amend an existing one. Courts can invalidate wills if the testator, person making the will, is found to lack the required mental capacity. 2. State laws. Varying regulations. State laws on disinheritance can vary significantly. Some states have protections in place to prevent complete disinheritance of children. 3. Reasons for disinheritance. Document. Reasons. While not legally required, documenting the reasons for disinheritance can provide clarity and reduce potential challenges from disinherited children. Legal requirements for disinheriting a child. 1. Explicit language in the will clear statement. Clearly state in your will that you intend to disinherit your child. General language omitting the child may lead to legal challenges. Example. Language. I hereby expressly disinherit my son, daughter, child's name, and intentionally make no provision for him, her, in this will. 2. No ambiguity. Specific identification. Identify the child by their full name to avoid any ambiguity that could lead to legal disputes. Consistent language. Use consistent language throughout the document to reinforce your intentions. 3. Alternate beneficiaries. Distribution plan. Clearly outline how the disinherited child's share should be redistributed among the remaining beneficiaries or another designated individual entity. Challenges and protections. 1. Forced heirship laws. Community property states. In community property states, e.g., Louisiana, forced heirship laws may prevent you from completely disinheriting children, especially if they are minors or have special needs. 2. Elective share laws. Marital protections. Some states have elective share laws that protect spouses, and in some cases, children. These laws allow a disinherited spouse or child to claim a portion of the estate, regardless of the will's terms. 3. Grounds for contesting a will. Disinherited children may contest the will on several grounds. Lack of capacity. Arguing that the testator lacked mental capacity when making the will. Undue influence. Claiming that the testator was under undue influence or coercion by another party. Fraud. Alleging that the will was procured through deceit or misrepresentation. Improper execution. Asserting that the will was not executed according to legal formalities. Alternatives to disinheritance. 1. Smaller inheritance, nominal bequests. Leave a nominal amount to the child, e.g., $1,000, to make it clear that the omission was intentional, reducing grounds for a challenge. 2. Trusts. Conditional trusts. Create a trust with specific conditions or restrictions, such as educational or behavioral requirements, that the child must meet to receive their inheritance. 3. Lifetime gifts. Prior gifts. Provide for the child during your lifetime through gifts or a trust, reducing the estate available for distribution upon your death. Steps to disinherit a child. 1. Consult an attorney. Legal guidance. Seek the advice of an experienced estate planning attorney to ensure your will is drafted correctly and adheres to state laws. 2. Draft a new will or codicil. New will. If you don't have a will, draft a new one specifying the disinheritance. Codicil. If you already have a will, create a codicil, an amendment to the will, to include the disinheritance clause. 3. Include a no contest clause. Deterring challenges. Consider including a no contest clause, interim clause, in your will, stating that any beneficiary who challenges the will forfeits their inheritance. Note that the enforceability of no contest clauses varies by state. 4. Sign and witness the will execution. Ensure the will or codicil is signed and witnessed according to state laws. Typically, This involves signing the document in the presence of two disinterested witnesses.